Jared Leisek, the founder of R4pe, was charged with child R back in November 2022. Today, we're going to go over the full detailed case history per the legal records and discuss it together. Hey everyone, Empowering True Crime, Alex here. And in case you don't know the background, I actually have a video I'm going to link here, which is the updated timeline through July with all of the important dates and background for this case. Today, I'm going to go over like all of the records line by line. And so it's going to be more detailed than that timeline, but that will give you a good overview of the entire case. Before we dive in, if you haven't yet subscribed to my channel, consider joining the Empowering family. Let's be the voice for the voiceless, missing persons, and others who can't speak for themselves. Today, we're going to be going over the legal documents. So, if you need to put on your reading glasses, go ahead and put that on. Let us begin. There are a few versions of this case file or case history. This is the more detailed one. There's another one that's cleaner and it just has the line items. But what I liked about this one is that it gives more detailed information for each of the more important dates and appearances, court appearances in this case. Okay, so this takes place in 6th Judicial District of Manatee in Sanpete County, state of Utah. This is the state of Utah versus Jared Leisek. So just a quick reminder here that this is not him versus her. This is a criminal case. The state is bringing criminal charges of child R toward Jared Leisek, okay? And so, because a lot of people keep saying like, oh, it's all about the money. Civilly, there could be something. But for this particular case, there is no money being exchanged. This is whether or not he gets convicted and gets sentenced, or whether or not he is found not guilty, or the case gets dismissed in some other way. Okay, so the charge, there's one charge. Originally, there were two, but there is one charge now. R of a child. It's a first-degree felony. The offense date is on or about January 1st, 1992. Location in Sanpete County, and it says there's a mandatory appearance necessary. So, quick background: the charges were brought by Jared's cousin, and she actually originally said that there were two cases or two incidents of R. One would have been in her home, which is in Ephraim. I think that's how you say it, Ephraim, Utah, and then the other one in a relative's home in Manatee, Utah. So the assigned judge originally is Mandy Larson, and she's still the judge presiding over this case. But there is a distinction here that in a minute or in a moment, there's going to be another judge that came up, and I don't know where he came from or why he came into the picture. But all right, let's continue. So the parties, back to what I was saying before, the plaintiff is the state of Utah, represented now by J. Wesley Mangum or Wes Mangum. Originally, the lead prosecutor on this case was Eric Butler, and we're going to go more through that in a bit. And then the defendant, Jared Leisek, represented currently by Kara Tangaro and Scott Williams, originally represented by Randall Richards. So both attorneys for the prosecution and the defense have changed during the course of this case. Let me go up here where it says law enforcement agency. Ephraim was city police, is where the original report was made. And the officer that was assigned to this case is Detective Corey Krebs. Prosecuting agency is Sanpete County. And again, it says here, the violation date is on or about January 1st, 1992. So at this point, it's over 30 years old. All right, so let's begin here. So it says that on November 3rd, that was the pivotal input date. Filed the information, the indictment was filed for this, for the charges. The case filed by the e-filer, filed from an information. The judge, Mandy Larson, was assigned, and the summons to issue was filed, as well as all of this electronic notification and all that was filed, okay? So here, this can seem a little confusing, but it does say canceled because Originally, the court appearance was going to be on November 30th, but then it was later canceled. And what I've noticed on this document, when the later court date is canceled, it goes back to the date where it was originally input and updates it there. So it's updating it on the date when it was originally scheduled. So the summons here, the summons was issued, and the clerk here stated as Andrea Ellis. Okay, so on November 4th, additional things were filed, return of electronic notification, and then the appearance of counsel, notice of limited appearance was filed. And then, so this was the attorney, Randall Richards, put in all of this. So there was a request for discovery was made, and then every time that there's anything going, anything that is returned electronically, there's always this notification, return of electronic notification. And then on the 8th also, there was a motion to appear by WebEx. So that was also included. That was filed by Jared Leisek. And so that's because he lives in Oregon and this is Utah. And so he put in, instead of having to go to Utah for his first appearance, which oftentimes is just, a lot of times it's scheduling and things like that, he made a motion to appear by WebEx, which was granted. So here it says the proposed motion to appear by WebEx, and then also filed on the 8th of November. It says the request notice to submit the motion and order to appear by WebEx. And that was returned, filed return of electronic notification. And then on the 9th, so one day later, the judge signed the order on the motion to appear by WebEx. So you see here where it says propose, that's going to happen a lot in this case as well. And that is that usually the different parties are going to, one or the other parties is going to come up with an agreement, stipulation of parties. They're going to agree to something. They're going to have a proposed document will be filed, and then the judge will simply sign it. And then that is the filed order. And that's what happened. So the judge agreed to the motion to appear by WebEx. That was on the 9th. And okay, again, filed return of electronic notification. And then here, the notice for the case, the reason for the change is the stipulation of parties. So that to me says that the parties agreed that his initial appearance would be via WebEx. And that's why the change was made here on the 9th. Modified initial appearance, WebEx, scheduled on November 30th, would be via WebEx. So Jared Leisek was allowed to appear via WebEx. Okay, so it doesn't state it here. Remember that there was a summons for his appearance for November 30th. Well, that was sent, that was actually given to Jared on the 11th, November 11th. An Oregon sheriff presented him that summons. And then that was returned to the state of Utah. You see, it says here service date, November 11th. So that's when Jared received it, and it got back to the state of Utah. It was filed on the 14th. So the return of service upon Jared Leisek. So again, because it's the state of Utah and he is in Oregon, that's why they needed to get in a local Oregon sheriff to present him the summons. Okay, now another filed return of electronic notification. Then we go to, all right, interestingly, there's no specific line item for what happened on 11/30th, which was his November 30th, which was his initial appearance. But remember how I said that oftentimes they do include it back when the original was scheduled? That's why it showed it up before. When the original was scheduled, they'll make the note there in the original. They don't give its own line item. I think that could be a little bit confusing, but that's why you go from November 14th to December 9th. So the initial court appearance was on November 30th. and the judge actually canceled court because there were YouTubers who were live streaming it, and there was a very, very clear waiver or clear disclaimer when you signed into the WebEx that you couldn't record, you couldn't photograph, you couldn't distribute or disseminate any court proceedings. It's illegal, and it's punishable. You could be arrested or fined for that. And you had some YouTubers who were, maybe weren't showing it, although I think some were. But you could hear there was audio of it, or audio of them speaking speaking about it or sharing about it. And so it was just a mess. The judge decided to cancel court. There were also the public that were very disruptive. I mean, I don't know if they realize that this is court. This is not, we're not at an improv show or anything like that. This was real court. And so the parties decided to cancel it. Judge decided to cancel it, and they agreed to reschedule for December 12th. So the initial appearance occurred on December 12th at 9 a.m. And let's see, notice for the case, minutes, entry. So this is what happened in the initial appearance. The presiding judge was Mandy Larson. The clerk was Andrea again. Prosecutor, here it stated Eric Butler. The defendant was present. The defendant is not in custody. And the defendant's attorney is Randall Richards. And so the initial appearance says here the defendant waives the reading of information, and the matter before the court for an initial appearance, court admonishes all participants about media rules and laws in the state of Utah. So that's really interesting, media rules. So I guess maybe they were talking again about the the fact that they're not allowed to disseminate or distribute or any type of recording or any photograph or anything from the court hearing. Mr. Richards reports they will waive the reading information, and Mr. Butler asks for a pre-trial protective order. So that is that Jared cannot contact or communicate with the alleged victim. That's what that pre-trial protective order is for. So the court agreed to issue the pre-trial protective order. The court orders the defendant to be fingerprinted and booked by the end of December, and Mr. Richards asks to file a motion and to seal that motion. Court will receive the motion under seal. And so I believe that it's probably because of the nature of the allegations that they didn't want to, air all the dirty laundry, so to speak, in the public. And completely understandable. I think nobody really wants to have that aired out. In fact, the original probable cause affidavit for the arrest was quite graphic, and I'm even surprised that was made public. But yes, it was, and it was graphic. So again, it says here the defendant is not in custody. Now again, one of the reasons why he had not been booked yet is because he was in a different state. And this is according to Eric Butler, the prosecutor. Jared Leisek was not in the state of Utah, and also the allegations were from 30 years ago, and so it's not like it was an urgent matter for him to be arrested in that moment. So on the 12th, there were a bunch of documents filed. One was the motion to dismiss by the attorney, which was sealed. So we won't see that motion to dismiss. Also, it says here, private filed memorandum in support of the motion to dismiss. So that was also made private, so we won't be able to read, at least not publicly, the motion to dismiss and the memorandum in support of the motion to dismiss. And in addition, there was a private motion to classify the memorandum in support of motion to dismiss, and an order proposed on the motion to classify. So this was all made private. So they want to classify. There was a motion to classify the documents, and so that originally it ended up being all of this is private, so we can't see it. It's sealed. And then again on the 12th, there is a filed order, proposed motion to classify amended. So again, remember when I mentioned whenever there's a proposed, that's not the actual order, like the order is not in effect yet. That's the proposed document. The judge will review it and then sign off on it, and that's when the order is in effect. So also what's sealed, the motion to classify the memorandum in support of the motion to dismiss amended. So it sounds like on the same day, they put in a proposed order on the motion to classify, they amended it, and so that's why there's all of these different line items. So maybe it might have even been something simple like a wrong date. It could have been something super minor, because for them to do it on the same day, it might have been something very minor. It might have been something big, or it might have been something small, right? It could have been a misspelling or something like that. And so so they ended up sealing all of that, so we can't read any of those documents. And then, okay, so the filed, and then, okay, so here is the filed memorandum. There's the filed motion to classify the memorandum in support of motion to dismiss amended, and the filed memorandum in support of the motion to dismiss amended. So that was filed. And then on the 13th, the next day, wow, so a lot of things happened on the 12th of December. That initial appearance happened, and all of these documents were filed, and the amended documents were filed. And then there is, on the 13th, the judge signed the order on the motion to classify. So all of these that were proposed, the judge actually signed it. So that went into effect then on the 13th. Filed order motion to classify amended. So I guess she signed the original and she signed the amended order as well. And then there's all of these notices, return of electronic notification. Okay, so on the 16th, the prosecutor puts forth a proposed order, pretrial protective order. Again, this is to protect the victim. This is like a non-communication, non-contact order. So Jared is not allowed to contact or communicate with the victim, with his cousin, during the entire pretrial period. And so I'm doing a video just where I'm covering that, and I'll link it here if this is published once that happens. Okay, so that was proposed, and then it was filed, the return of electronic notification, and then on the 19th, the judge signed the order, the pretrial protective order. So that went into effect then on the 19th. And then you see here, so it was filed, return of electronic notification. And so it was, note here, pretrial protective order service date, 12/19/2022. And so it was funny because I believe that they just put it just for like, they just put like a random date. And I think the random date was through the year 3000, a ridiculous timeout. And so I guess it's just kind of like put it in like almost like infinity in a sense, right? So this pretrial protective order is in effect for a long, long, long time. Okay, so filed protective order, pretrial protective order, signed December 19th. Filed return of electronic notification. Okay, so on December 22nd, there was a notice made, so it was filed, the scheduling conference is scheduled for January 20th. Now, if you watch my timeline, they had actually scheduled the scheduling conference for the 23rd, but I guess on the 22nd, they decided to change the date to January instead. So here it says on the 22nd, it also says a scheduling conference scheduled for January 20th at 8:30 a.m. with Judge Mandy Larson. Okay, so you have the notice for the case has filed, the return of electronic notification, amended information, return of electronic notification. Oh, oops, that's back in the 10th. Okay, sorry about that. Okay, so that was December 23rd. Now, on January 5th, Jared was booked. And remember that at the initial appearance, they said booked and fingerprinted by the end of December. So it actually happened on January 5th. So he was given 5 extra days to complete that. And then, okay, so here 110 filed and filed. Okay, so this is what happened here then. So not only was he booked then on the 5th, but then there was one charge was deleted. So originally there were 2 child R charges. Now there's only 1 charge. And so I believe that's what this filed amended information, all of that is, because then there's a note here that the deleted charge, oh yes, actually, that's exactly what it is. So this on the 10th is when the document showed up that the charge was being deleted, but then there's a note here on the 11th that the deleted charge and what the charge is. Now, if you recall, the defense attorney put in a motion to dismiss the case. And what happens behind the scenes whenever there's a case like this is that he put in the motion to dismiss, then the prosecutor is going to come back and give their response, and then usually then the defense attorney gives their response to the response, and back and forth. And that might happen a few rounds before the next hearing date. So what happened here, and I think this is because of the date change, because it was originally going to be on the 23rd, and then they pushed it back. I'm sorry, in December, but they pushed it back to January. So here there was and this is sealed because this is going to probably give a lot of more background information. There's an objection to the state's objection to the defendant's motion to dismiss on due process grounds and statute of limitations grounds. And so that was filed and sealed. And then so this is also the amendment. Okay. So they filed the state objection to the state's objection. And then on the 20th, that happened on the 19th, and on the 20th, there was a filed motion to seal the state's objection to the defendant's motion to dismiss on due process grounds and statute of limitation grounds. So that was filed by the state of Utah. So anything that is sealed and any response to anything that needs to be sealed needs to continue to be sealed. And so that's what this whole thing is about here. So there's a bunch of orders here about sealing the different responses. So also on the 20th, there's an order. This is a proposed order to seal the state's objection to the defendant's motion to dismiss on due process grounds and statute of limitations grounds. There was a filed return of electronic notification. And then you see here it was proposed. So it was actually signed that day, the same day, on the January 20th, the order to seal the state's objection to the defendant's motion to dismiss on due process grounds and statute of limitation grounds. So that one was signed off by the judge. Another return of electronic notification. Then on the 20th, so remember there was a scheduling conference. And remember I said that whenever it's scheduled, they'll include it. So here they included the oral argument via WebEx was scheduled on March 8th. That's what happened at the scheduling conference on January 20th. So here's the minutes for the scheduling conference on January 20th. The judge is Mandy Larson. The clerk is Tiffany O. Prosecutor Eric Butler. It says the defendant is present. The defendant is not in custody. The defendant's attorney is Randall Richards. And it says the matter is before the court for scheduling conference. Mr. Richards reports he's aware of the amended information and waives the reading. Mr. Richards requests additional time to respond to Mr. Butler's objection. Mr. Butler also requests time to respond. So that's part of this all, remember that the prosecutor put the objection to the defendant's motion to dismiss. And so the defense attorney now needs to respond to that. And then once he responds to that, then the prosecutor needs to respond to that. So it's a back and forth with all of these different responses. Court allows each party 1 week to file responses and schedules the matter for oral argument. So they scheduled the oral arguments for the motion to dismiss on March 8th at 3 p.m. before the judge, Mandy Larson. This hearing will not take place at the courthouse. It will be conducted remotely. Contact the court to provide your current email address. If you do not have access to a phone or other electronic device to appear remotely, notify the court. So that was open via WebEx. I attended, as well as many others. So on the 21st, there was a filed return of electronic notification. So on February 3rd, there was the responses start to roll in. There was a sealed filed motion to classify, reply memorandum to the objection to the motion to dismiss. So everybody's starting to respond now and file those responses. Again, there's a private order on the motion to classify, and that was proposed. So usually when there's proposed, it sounds like there is like a stipulation of the parties. So both parties, the defense and the prosecution, come to terms and put this proposed document to the court. So that's a private document as well. That's a motion to classify. Then there's another sealed reply memorandum to the objection to the motion to dismiss. So that was also sealed. And then there's the order on the motion to classify was signed. So this proposed order was signed on the 6th of February by the judge. And then that day there is a filed return of electronic notification. Okay, so on the 8th, they had their oral arguments, but in here on the this docket here, they actually, remember I told you that whenever they schedule the hearing, they're going to include it, and if there's any cancellation, they're also going to include it on the same date where it was scheduled. So the preliminary hearing that was scheduled at the March 8th motion to dismiss hearing was canceled. So we'll go into that in just a moment. So on March 8th, they had their oral arguments. It was done via WebEx. I attended. Again, nobody's allowed every time there's a WebEx to record, photograph, or distribute anything from the court proceedings. So presided by Mandy Larson, clerk Tiffany O, prosecutor Eric Butler. The defendant was in person, but not in custody. The defendant's attorney is Randall Richards. And it says, the matter is before the court for oral argument on the motion to dismiss. The hearing is taking place over WebEx and is being recorded on FTR and WebEx. Mr. Richards addresses his motion to dismiss. Mr. Butler argues against the motion to dismiss, and Mr. Richards with argument, and Mr. Butler with rebuttal. So it was, there was a little bit of ping pong there, right? And then the court, with the ruling on the motion to dismiss, the court denies the motion to dismiss. So the judge denied the motion to dismiss. Mr. Butler is to prepare the order from today. That's the prosecutor. And at that meeting, because the case was not dismissed, they scheduled the preliminary hearing for April 5th. And it says here, was going to be before the judge, Mandy Larson. So what was weird, though, is that, remember a minute ago, I told you that it was scheduled and then it was canceled. Here it says preliminary hearing in person scheduled on April 5th with Judge Marvin D. Bagley. So I'm not sure what happened there. I don't know if that was if that was a typo, if maybe he was going to replace Mandy Larson because she had a conflict. I'm not exactly sure or entirely sure why this happened, but in any case, that April 5th hearing was canceled anyway. So that didn't end up happening, and it was rescheduled. So that one was rescheduled. So the preliminary hearing in person was rescheduled to April 19th, which was also canceled, but that's for a different reason. So this April 5th preliminary hearing ended up getting rescheduled to April 19th. So let's continue. On March 10th, there was a filed order proposed, rulings and order on defendant's motion to dismiss. And then that ended up, let's see, there was a return filed return of electronic notice, filed request notice to submit, and then another filed return of electronic notification. And now I actually took this document out and it didn't say anything new or additional, so I'm not going to share that specific document. Okay, so on the 28th, they set the preliminary hearing in person for April 19th. So before it was originally going to be on April 5th, and then on the 28th of March, they rescheduled that to the 19th of April. So new date for the preliminary hearing in person before the judge, Mandy Larson. Now, again, I don't know if there was some wonky thing there with the other judge that was assigned. I don't know if that had anything to do with this, but in any case, it was scheduled. It was pushed back a couple weeks, and it was rescheduled for the 19th. And remember, I told you, whenever they schedule a hearing on that same date when they schedule the hearing, they'll also mention if there was any cancellation. So the preliminary hearing that was scheduled for the 19th was canceled. Now, this one has a different reason. The reason for this one, and I guess there's nothing else really. So the reason for this one is that the defense got new attorneys. So Jared replaced, or he got rid of his previous attorney and got two new attorneys. That's why it says here reason, defense attorney request and stipulation. Okay, so on the 28th, there is the reason for the change is, it says here, stipulation of parties court motion. So that's the reason why the preliminary hearing was rescheduled. Not this one. It's a little bit confusing, but I hope you follow. The reason that the original preliminary hearing was rescheduled, it was a stipulation of the parties court motion. The reason that the preliminary hearing was canceled, that one, the newly scheduled one, is because of the new attorneys, and we're going to get into that now in a moment. So, okay, so there was a filed notice for the case. Mandy Larson filed return of electronic notification. And then there's a filed order on the motion to dismiss. So what this is this was the basically the opinion that Judge Mandy Larson gave. It was dated March 31st, of why there was the order on the motion to dismiss. So why she denied the motion to dismiss. And she outlines the arguments of the defense attorney and what her opinion was on each of those, and why she decided to deny the motion to dismiss. And I do have a video where I talk about not only the hearing itself, but also covering that document, this opinion from the judge. So that was filed on April 4th. And then there's filed return of electronic notification. And then on April 8th, there's a filed other not signed order proposed rulings and order on defendant's motion to dismiss. Now, I'm going to share this because I actually had no idea what that meant. So this is a document, and it says here was not signed. So it was a not signed document. So it was filed, but it wasn't signed. So this was the order on defendant's motion to dismiss. And it says here, on March 8th, 2023, this matter came before the court for oral arguments on the defendant's motion to dismiss. Both parties filed written memoranda, which the court reviewed prior to this hearing. So this was a document that the judge asked Eric Butler to prepare. And so this was one of the documents that he had prepared, but this one was not signed. So this was, in the end, it says the court orders, based on the foregoing findings, the defendant's motion to dismiss is denied, and a preliminary hearing is hereby set for April 5th at 3 p.m. in person at the courthouse in Manatee, Utah. So because there was a change there, because it ended up being rescheduled, maybe that's why this one particular document was not signed. So that's what this is, a not signed order proposed. And then there's a return on electronic notification. Okay, so here we get 4/18, April 18th, there was a request for discovery. Why? Because of the new attorneys, the new defense attorneys. So also on the 18th, there's a substitution of counsel. That's when Jared replaced his former attorney with Kara Tangaro and Scott Williams, the two new defense attorneys for his case. On the 18th, there's also the return of electronic notification. And then there's the stipulated motion to continue the preliminary hearing and set the scheduling conference. So that because there was a new attorneys, they agreed to continue the preliminary hearing and have a scheduling conference instead. So that's why when we read before that preliminary hearing on the 19th had been canceled due to defense attorneys, that's why. Okay, so then on the 18th, there's a order proposed continuing preliminary hearing. So that's a proposed document, remember. So the parties will stipulate, they'll come up with that agreement, they'll send it over to the judge will sign it, and then that's when on the 18th, it was a filed order, the order continuing the preliminary hearing and setting the scheduling conference. That was signed by Judge Larson on the 18th. And then on the 18th, that's also because they agreed to set the scheduling conference. That's when the new scheduling conference via WebEx was scheduled for May 3rd. And that would be presiding with Judge Mandy Larson presiding. Okay, so then that was filed return on electronic notification. Now, the scheduling conference on May 3rd. That was, clerk here says Tiffany O. Prosecutor is Kevin Daniels. Now, here's where things start to get a little interesting. There's a few details that I'm not 100% sure on, but I'm trying to piece together based on the information that I've gotten. The legal secretary told me that Eric Butler, the prosecuting attorney on this case, got a new job at the Utah Attorney General's office. So on May 3rd, the prosecutor shown is Kevin Daniels. He is the lead prosecuting attorney for San Pete County. Under him, there were two deputy attorneys, Wes Mangum and Eric Butler. Eric Butler was the prosecuting attorney for this case, but here it shows Kevin Daniels. Now that could just simply be he's the boss and he presided over this particular scheduling conference, or it could be that Eric Butler got a new job in May. So I don't know if the dates are lining up or what, but the prosecutor here on May 3rd, as early as May 3rd, was Kevin Daniels. Okay, so here it says, and the defendant's attorney that was present was Scott Williams. Mr. Williams, the defense attorney, requests the matter be scheduled for preliminary hearing, and Mr. Daniels, the prosecutor, agrees. Judge Larson states there will be no WebEx for the hearing. Now, here is also later on, Wes Mangum, the new prosecuting attorney for this case, said that there was a conflict. And I wonder if it's because Kevin Daniels was the one that was presiding over this, not Wes Mangum, and therefore the dates didn't line up. So either Kevin Daniels was maybe going to be taking on this case, or then he was reassigned to Wes Mangum, and then therefore there's the scheduling conflicts that Wes Mangum later asked to reschedule the preliminary hearing because he was assigned to this case. So in May, the preliminary hearing is scheduled for July 10th. And so here it was scheduled the next day. It was in the books the next day, May 4th. But remember, if there is later on it gets canceled, it gets noted way back when it was originally scheduled. So it eventually ended up getting canceled, and we'll talk more about that in a moment. And the reason is the stipulation of parties. Okay, so on June 29th, there was an proposed order to vacate the special setting preliminary hearing and set for scheduling conference. So, and here it says the reason why, the stipulation of parties. Now, it was agreed upon, but the reason is that Wes Mangum had a conflict in his schedule. So Wes Mangum being the new prosecuting attorney for this case. He is not a new prosecutor for St. Pete, but he is the new prosecuting lead for this case. It was previously Eric Butler. And so then the order was, there was the proposed order, and then it was filed. And again, it says private here. Not sure why it was private, but stipulated motion to vacate the special setting preliminary hearing and set for scheduling conference. And it was signed by the judge on July 3rd. So the order to vacate the special setting preliminary hearing and set for scheduling conference was signed. And so so the scheduling conference was set for July 12th at 10:30 a.m. and that actually ended up happening. So the order canceled the preliminary hearing and set the new scheduling conference for later that week. So it was going to be preliminary hearing was going to be on July 10th. That was canceled, and a scheduling conference was scheduled for the 12th. So at the scheduling conference, the new prosecutor listed here is Wes Mangum, J. Wesley Mangum, also referred to as Wes Mangum. And the defendant's attorney was Kara Tangaro. She was present. It says here, the matter before the court for a scheduling conference, counsel agreed to reschedule an in-person preliminary hearing. The meeting was super quick. In fact, there was a roster of other cases that were being heard that same day. And so once they got together, Kara Tangaro said that she didn't have any availability in August because her schedule, or through August, because she is involved in a lot of other hearings. So she requested September, the earliest, and they came to terms with September 11th. So that is the date set for the preliminary hearing. They're going to reserve the entire day for that preliminary hearing. It might not take, more than a few hours. It might be super short. I don't know, but they have the entire day scheduled for the preliminary hearing in this case. So then on the 17th, the notice for the preliminary hearing being scheduled in person was filed. And so now we know that that date is set for now. The preliminary hearing here, it says preliminary hearing in person scheduled on September 11th. And then the notice for the case was filed and the return of electronic notification, so that everybody agreed. And so that's where we're at right now. So are you a little cross-eyed like I am? I'm such a nerd. I love reviewing documents, but that was a lot. Like I'm going to need to take a break. But because I'm just kind of like, now that I've gotten more access to these documents and all that, and I'm looking at different documents, I'm going to be doing a few other videos, just kind of going deeper into a few different items and a few different matters, so that we can get a better understanding of those, especially since the case is not going to, the next hearing is not going to happen until September. We have some time to kind of go deeper into some of these issues and matters and clear up a few things, because there is, frankly, misinformation on all sides in this case. And so I like to bring in the facts. I like to dive a little bit deeper, investigate further, and see what we can clear up, because it doesn't help anyone to be putting out misinformation. And so I think it's really, really important to have the facts straight, so that we can have a more, just a more well-founded opinion on the matter. In the end, the defendant is innocent until proven guilty. At the same time, statistically, it's very unlikely that false allegations happen. A very, very small percentage of false allegations happen in any crime. And an SA is statistically underreported. And so, whatever camp you're in, or if you're neutral, still, it's important to have correct information, as much right information as possible. So I'm kind of looking through the court records every week, see if there's anything new that pops up. And so this is the latest so far in the court file. That's the latest information that's in this document or in this video. And of course, if there's anything else new, I will let you know. But until then, we're going to dive in deeper into a couple of other matters that I find interesting and I think that we need to explore more. And with that, if you learned something today, if you enjoyed this video, please hit the thumbs up. Let's get this out to more people so that we can get more correct information, factual information out to more people that are interested in this case. If you haven't yet subscribed to my channel, I'd appreciate if you join the empowering family. Let's be the voice for the voiceless, for missing persons, and others who need our support. And of course, more updates and more deep dives on this case. All right, everyone, with that, stay safe, stay thriving, always follow your intuition, and make sure to keep it empowering. Bye for now. Don't forget to like, subscribe, and hit the bell button for notifications. Thank you.